Welcome to Transition Plans. I'm Bill Stalter. In this webinar, we're going to talk about the durable power of attorney for finances.
Clients often come to their first meeting with me thinking that they need a general power of attorney. Now, the general power of attorney is a legal document that covers both financial issues and healthcare issues. I advise clients against the general power of attorney because of their family members or friends. There's somebody more suited for financial issues versus healthcare issues. So I always recommend separate powers of attorney, one for financial affairs and one for healthcare issues. The power of attorney for finances is also referred to as a power of attorney for property. Now, the financial power of attorney is the most widely used life contract. It serves both as an estate planning tool and as a document of convenience. Clients use the power of attorney for finances to assist an aging parent, or they use it for college-bound children, or for themselves. Now, this webinar is just going to be about the financial power of attorney. However, I do have another webinar on the Transition Plan YouTube channel about the healthcare power of attorney. The durable power of attorney for finances is a legal document that authorizes the person you designate, who we call an agent, to pay bills and execute documents while you're away, or if you lose capacity to make decisions for yourself. The power of attorney can either be durable or non-durable. A non-durable power of attorney remains effective only for so long as you have capacity to make decisions for yourself. A durable power of attorney remains in effect after you lose the capacity to make your own decisions. Almost all of my clients want a durable power of attorney. Now, state laws determine what a power of attorney form must include so that it will be treated as durable and allow your agent to conduct your financial affairs when assistance is needed most. The aging parent is a topic that comes up frequently during client meetings. With the gradual decline in cognitive abilities, it is natural for parents to forget to pay bills and to miss important deadlines. And failing eyesight or hearing may also play a factor. And while COVID is no longer as dangerous as it was in 2020, elderly Americans remain the most vulnerable. Most will survive, but seniors are more likely to suffer from brain fog. Cognitive abilities may be impaired for months or longer, and symptoms are very similar to Alzheimer's. Clients frequently inquire about powers of attorney for the parent that needs a little assistance maintaining their independence. Clients describe how the parent has become susceptible to scams, and the parent may be more compulsive when watching advertisements on television. In some situations, it's taken years to discover the parent has mismanaged their resources. And in worst case scenarios, the parent ends up in financial ruin and can no longer afford to live at home. A durable financial power of attorney can serve as a safeguard against imprudent transactions by the parent. With a POA, the agent can monitor bank accounts, credit cards, and challenge fraudulent activity. And when caught early, the agent can also reverse transactions that are just imprudent. While a parent may be reluctant to share control over their finances, the financial power of attorney can be used to extend their independence. Signs that a financial power of attorney might be needed for a parent. Mail is often pushed aside or thrown away without being opened, and bills for utilities, medicine, and taxes go unpaid. Parent is confused about taxes and the need to file a return. Or parent could be confused about Medicare options and frequently asks for help. I've also seen where the parent asks the same question frequently, and the individual becomes defensive when reminded of that fact. I also look for when deadlines are frequently missed, or tasks are completed but then forgotten and repeated again. Or watch for the parent who has difficulty with decisions about records that should be retained or destroyed. And again, vision or hearing that deteriorates to the point that they can no longer confidently read financial documents or negotiate telephone transactions. If you have a child preparing for college, a power of attorney for finances for that child will enable you to assist them to navigate a university system that considers them an adult. Clients have been frustrated when a bursar's office denies them information by citing the child's privacy rights. This is particularly true when the child forgets to pay bills when the parent is footing the tuition. College life means new levels of independence for the child, and frequently the child becomes overloaded with new friends and activities and lets tasks slide. Having a financial power of attorney in place for the child will avoid frustration when dealing with a bursar's office that follows the university's rules on privacy and will not release information to the parent. Clients approaching retirement age may not see an immediate need for the financial power of attorney. Unlike the other estate planning documents that may be viewed as end of life in purpose, the financial power of attorney can be a tool of convenience. My wife and I are planning for trips next year that will take us away for weeks at a time. If something comes up while we're away, our son has our financial power of attorney and can take care of matters that might come up. This happened a few years ago when we were out of the country. And the financial power of attorney can serve as insurance should an unforeseen emergency occur. No one plans on getting COVID, but thousands of Americans are still catching it. And while most of us will survive our second or third bout with COVID, our chances of developing brain fog are getting greater. We may need some assistance until we can get back on our feet mentally. For clients who do seek a financial power of attorney for themselves, I suggest they look beyond their spouse in most situations. When property is jointly held, a spouse already has authority to pay bills and take care of marital property. Instead, the power of attorney should be looking forward to the situation where the spouse is not available. The person you select to be your agent should be someone that you can trust to take care of your financial affairs. Your agent will be paying bills and filing tax returns, instructing 401k administrators, and coordinating your benefits for Social Security. The agent should have the patience required to spend time with you to review your financial situation. This should include going over bank and brokerage account statements, business investments, insurance, and retirement accounts. On the flip side, there should be a review of your financial obligations, including monthly bills. Your choice as an agent could be an adult child, a family member, a life partner, or a friend, but it needs to be a person who has the skills necessary to make financial and business decisions on your behalf. It would not be wise to appoint an individual with their own financial difficulties or who lives too far away to assist with day-to-day decisions. When clients ask about appointing two people as co-agents, I generally recommend against that. Many banks do not accept co-agents, or when they do, they require both people or persons to sign the document. What I've done in some situations was to prepare two separate power of attorney forms. If the person that you're choosing as an agent does not live close in proximity, then it should be someone who has experience transacting business remotely or online. And the person should be prepared to provide an annual accounting. When you put a financial power of attorney into place, you will want to put your financial institutions on notice. Banks and brokerage firms are notorious for requiring their own power of attorney form. These forms include additional protections for the bank. Financial institutions are not shy about rejecting other power of attorney forms in favor of their own. If this were to happen after you lose capacity, your family could be forced to open a conservatorship. So you need to be proactive and avoid this by taking your power of attorney to the bank and requiring them to accept it or tell them you'll take your account elsewhere. If you still have questions about the financial power of attorney, then I would suggest visiting Transitions Plan's YouTube channel, where we have additional power of attorney videos. We also post information to the Pre-Need Resource Facebook page and also to our Death Care Law Compliance blog at www.deathcarelaw.com. If you're participating in a planning seminar sponsored by one of our affiliated hosts, we will have additional Zoom meetings where we can answer questions. Your host will also provide information about discounted costs for our essential life contracts.